And understanding that you're focused more on the federal level, in Minnesota, there is no protection of citizens against judicial decisions that by any objective standard totally disregard established law. And that's one of the things that is trying to take steps to remedy. There is no accountability for the judiciary in Minnesota. That accountability accountability rests with the legislature by the Constitution, but the legislature has advocated that responsibility. That's state level stuff.
I think on the state level, it's hard to change the law at the legislature. And sometimes judges tend, we're always aware of, we're advocating for changes in the law. Mm-hmm. We're always against the law as it's currently interpreted. And so when a judge is deferential to the nuttiness that happens at a city council or the nuttiness that happens at the legislature, we generally lose. And so that level of protecting the status quo is difficult for us, and I suspect it's difficult for a lot of people. Yes, sir.
This is a little bit off subject.
No, bring it on.
Well, okay, would the Institute of Justice get involved in something like the Boeing case, in NLRB, saying, Boeing can't build a plant in South Carolina because it's a right-to-work state, because the NLRB is favoring the union position?
We're in that sort of church of economic liberty, but the fine people at Boeing can afford excellent lawyers. and so I have no fear that they will have the most very talented legal representation. The other dynamic that we also look at is the multiplier effect. Will that case apply to other people? And the answer is probably yes. That will be a very important case. And so that passes the test. Then the other question we'll ask is Boeing going to settle this case, or are we going to get a really clean, crisp opinion? Well, Boeing's a pretty sophisticated company. They got a lot on the line. The NLRB's got a lot on the line. This may not come. Who knows? Maybe it does go all the way to the Supreme Court. Maybe we get a clean, crisp opinion from it. Or is it more likely to settle with some mushy disease? So those are the type of things that a public interest law firm thinks about before it takes it.
And that's something maybe to consider, is that, Lee kind of makes it sound like they go out and pick their clients, but in the last analysis, the client makes the decision about something like, are we going to settle or not? And so you do have to be careful who you take on as a client.
Well, that's a very good point. Our first obligation is to our clients. And so if the client says, I'm happy with a license that has 30 hours of training, let's not go for the complete free market, then we pursue that. Dennis.
Can I throw out one more general question?
Sure.
There are many people who believe that the state or the federal government and the courts on the federal level have gone way too far and held what many would consider an untenable position regarding the interpretation of interstate commerce.
The Commerce Clause.
Do you see anything that could bring that back more toward, let's say, a traditional view of the Constitution?
Oh, sure. Obamacare.
Yeah, okay, that could be an interesting.
So the powers, put on your 18th century hats. Why was what were the 13 states really concerned about in terms of giving power to the federal government? Well, they were concerned about losing power in state capitals, and so the power that the federal government has includes, but is limited to, the regulation of interstate commerce. Well, there was a famous case in the 1940s, Wicker v. Filburn, that said that, I forget whether it was Mr. Wicker or Mr. Filburn who was the farmer. Do you remember?
I don't remember.
I don't remember who the farmer was, but he grew wheat. He fed it to his own pigs, and the federal government wanted to limit the production of wheat. And he said, "Well, I'm not engaged in interstate commerce. I'm not even engaged in commerce. I'm just feeding my own animals with this when I'm growing." And the the Supreme Court said, "Sorry, farmer Wickard or Filburn, you lose." And the federal law limiting the production, the growth of wheat, applies to you, a farmer who's not engaged in commerce, who is also not selling anything.
Yeah.
You can go forward to the medical marijuana case, the Raich case, in which a woman suffering from a horrible disease was getting marijuana, and the federal government said to the state of California, stop providing for marijuana. Well, she was not buying marijuana, and she was not engaged in anything interstate. It was just, she was getting marijuana from the local co-op, and the Supreme Court ruled that even though something was neither interstate nor commerce, that the federal law applied to her. Now, those who want a narrower, those who are in favor of a narrower interpretation of the Commerce Clause have won regarding and federal laws that regulate guns and Lopez and Morrison. And I think the Morrison was violence against women, and those were so federal laws about regulating guns and federal laws regulating violence against women were struck down because neither of those were considered commerce or interstate. But that's the way the federal government regulates what happens in Minnesota, through the Commerce Clause. And in the Obamacare, the federal government is saying, we're going to mandate you must buy insurance. And the authority that we have to mandate that you must buy insurance is the Commerce Clause. And the argument against that is, say with me, I don't want to buy insurance.
I don't want to buy insurance.
So can the federal government regulate inactivity? Doing nothing. Now I know you're good at doing nothing. There's your chance. There's your chance. There's your chance to say, I'm good at doing nothing, including not buying insurance. You, Mr. Federal Government, you can't regulate me and force me to move from my marvelous position of inactivity. And that's the big issue in Obama, from a Commerce Clause perspective. That's the issue in Obamacare. Does that make sense?
But the enforcement of that is through the IRS mechanism in terms of coming back and just applying a additional tax. So the tax compliance issue, and that's the other hook.
Yes, there's a penalty, there's a tax penalty, but the tax penalty is whittled down to something.
Unfortunately, they made the mistake of insisting at the lower levels that the mandate was absolutely key. It's even written into the constitutional record, or the congressional record. So They
Is
made
it-
the mandate, the centerpiece.
Right.
And that way we get that as the question. I don't think that
Right.
the taxing power is gonna be.
That's exactly, the taxing power is not going to save this.
No.
Yeah, the question is, does the Commerce Clause empower the federal government to force you from your marvelous position of inactivity? So, yes, sir.
I have a question. You said you had an office in Phoenix, Arizona?
Yes, Phoenix.
Do they get involved in the, we're talking about enforcement, the lack of federal enforcement in terms of the immigration cases down there where the state has jumped in and said, well, if you're not going to do it, federal government, then we're going to do it?
We have not done that. We stick to these 4 pillars. We have promised our donors that this is what we're going to do, and when you invest with us, this is what we're going to deliver. And the other dynamic, and like the Boeing's getting good lawyers, the other dynamic is there are lots of lawyers out there, and there are lots of public interest law firms, and so staying focused on those things that we do is pretty important, and letting others do what they do is also important.